Here we go. Okay, we are now officially recording. Oh, sorry, folks. I keep advancing our slides when I'm trying to do other things. Okay, there we go. Hi, folks. Let's officially start our event now that we're recording and Jeanette has all the controls under control. I would like to officially open our session today by expressing my gratitude that we are able to gather virtually on the shared traditional unceded territories of the Squamish Nation and the Lilwat Nation. We are so lucky to live, work, and play in these territories. If you happen to be joining us from elsewhere, I'm always curious to know. So if you do want to send us a message in the chat letting us know where you're joining from, it's just out of curiosity. I'd love to know where our audience is coming from. And of course, we are all here today for our Lunch and Learn with Mac March session. And of course, as you can see on the screen, we are talking about estate planning with Peter Shrimpton today. And I am really delighted to be presenting this series in partnership with our friends at MAC. It's been a great series so far, and we are continuing to meet on the third Thursday of each month at noon, at least until May. And I know the April session will be sort of in the arts and culture realm. We'll announce the subject very soon, but it'll be something totally new for the series in April. So if you're keen to join us, if that's piqued your interest, you can send me an email and let me know that you would like to join us in April. So that's about it from me. I'm just going to repeat one more time that if you have questions today, we can't hear you or see you because we're in a webinar, but you are welcome to use either the Q&A function or the chat function to ask questions. And as I said before we started recording, Q&A is not anonymous, so your name will always be affiliated with your question. If you have a more sensitive question and you'd like to be anonymous, you can send a private chat message to me or to the panelists. And when I read out your question, I won't include your name. Okay, that is it from me. Oh, we do have someone joining us from Surrey. Hello, Surrey. So that's it from me. Peter, take it away.
Thanks very much, Jeanette. And it's a great privilege to be invited to deliver this presentation for MAC. I was invited by the chair, Kathy White, who's in on the call. I've had the pleasure of knowing well for, I guess, since the 1980s, Kathy, when she was a high-level ski instructor. I've been a member of MAC for 5 years now, and therefore you probably know my age. And I love the role it plays in making Whistler a more rounded community. And for those of you 55 and over, I do strongly encourage you to join and to become active in it. Thank you also to the Whistler Public Library for where I've enjoyed a great many of its offerings and programs over the last, I guess, 15 years since the new building was built at the new location. Special kudos to Jeanette Bruce, of course, for her role in ensuring the efficient delivery of all these programs. And like Kathy White, she wears many hats in her ongoing community building efforts. So a little bit about me. Like many of you, I've been hiking and skiing in Whistler since the mid-70s, before Blackcomb was even envisaged, and before, I guess at that time we were dumping our garbage right in the trenches where the village now stands, alerted only to where the bears were by slamming the car doors so we could see their heads pop up. I moved here full-time in the early 90s, and my 4 children were all born here, with 2 of them having Whistler on their birth certificates, actually. So while business and real estate law form the backbone of my law practice here in Function, wills and estates is certainly soaring in demand. I think I've probably done more wills this year than in the last 5 or 6 combined. It's a function of, since COVID, people being at home thinking about these things. And I'm very proud and delighted to have 4 dedicated legal assistants who are the real backbone of the practice. So on to the first slide, or the second slide, please. So there's the overview. I've timed myself. I'm only going to take 30 minutes. I could talk the whole day about this vast area. And so it really is going to be pretty introductory. I've seen the names of the participants. I know a lot of you are probably going to be wanting to ask more specific questions, but you're going to have to phone me or email me. The questions that I'll be answering, I hope, will be more general in nature. And if you have specific problems that are arising or specific fact patterns, then of course, you should be seeking specific advice. As a consequence of all of that, just please understand that this is general advice, general information. It's not specific legal advice. And there's always so many different interpretations and sort of a legal analysis that needs to take place for specific fact patterns. So there's over a dozen slides. I guess I see the number up there is 15. And the overview is as shown. Going to break it down into four segments, and then the end, you should have 15 to 20 minutes of Q&A. And again, I encourage people who are a little bit shy, perhaps, who have specific technical questions to reach out to me with the information on the very last slide. All right, on to the first part, which is about initial preparation and planning. So communication is key. I can't, well, that's for everything in life, really, but I can't emphasize enough the fact that you really need to be talking to family members, certainly spouses, those who have them. I encourage you to speak to the next generation, and it might even be the next generation, as this is designed for Mac. Those of you who have grandchildren, hopefully have good relationships with them, and you feel free about talking about your plans, which would include things like burial, cremation, celebration of life, obviously different during COVID times. So you might want to give current instructions and then post-COVID instructions in that regard. It always amazes me how frequently people will phone up and say, so-and-so died. We have no idea how they want the celebration to be held, and whether it's a burial or cremation. I mean, these are so fundamental. I don't know. I'm not going to say anything more about it. It seems so basic, but go ahead and write that down. I have a specific information sheet that I have. All the banks and credit unions would also have one in which you can update lists of your assets. List your liabilities, of course, list loans to family members that maybe needed to be paid back or not paid back, and certainly dealing with things like gifting assets. You can, during your lifetime, and it's to be encouraged, if you're capable financially, to give, whether that be to charities, to needy family members. You can also loan it to family members, and it's only a 1% interest rate that you should be declaring to CRA. But again, that's getting too technical, so I'm going to back off that one. So family finances and family business. If you, even at our age, still having to run a business, you've got to give special precautions. I, for instance, I've got backup lawyers in other law firms who would take over if something happened to me. For you, you've got to realize, those of you who have lived through the recessions, that it's not always the good time. I mean, we've been lucky with COVID with a lot of government support, but you know, there's always inflationary concerns, increased taxes, which I'm going to talk about near the end. And so you've got to be ready for the tough times as well as the good times, and organize your finances with the assistance of a good financial planner. You can use life insurance to cover some of those things. We've got Diana Sillery on the line as well, who's very good, Sun Life representative. There are great tax accountants in town. I deal with BDO and Gordon Weiber's offices here in Function, but there are great ones as well in Vancouver. You really do need to speak to a financial planner about your affairs. Don't take it lightly. And then, of course, the most important thing, I think, of course, is to obtain good legal counsel, an experienced lawyer who is familiar with wills and estate planning. It's a bit of a specialized field. You could go to a notary, for a very simple will. They can't do the more complicated wills with trusts, but generally the pricing is about the same. That's about it. I'm watching the time, so we got to keep going. Next slide, please. So, as part of the initial preparation, you can do a lot of planning outside of the four corners of, for instance, the will, of what happens upon your death. And the best planning is probably to talk to your financial planners or your advisors about how the beneficiaries, those who are to receive upon your death, how they're identified in your registered plans, RSPs, RIFs, and TFSAs. Typically, of course, it should be the spouse. There are a lot of capital gains tax deferrals if upon a spouse's death, if it goes to another spouse, or indeed to a dependent child. But you also need to consider the unfortunate possibility of perhaps both going at the same time. And so do name contingent or secondary backup beneficiaries. Most people don't do that. It's not, I haven't seen financial planners pushing that, but you really don't want to have your very considerable investments, hopefully considerable, that have accumulated over time, fall into your estate, and thereby attract the probate fees that I'll be talking about at the very end. Ideally, it does go to somebody. It can go to somebody in trust for the benefit of the estate, but again, that's a little bit more complicated, and I'd hope that you would discuss that with your legal counsel and financial advisors. Okay, organize a will. So we're going to actually have slides coming up on each of these topics: the will, the power of attorney, the representation agreement. So let's go to the next slide then. So preparing your will. There's the little cartoon I found that was appropriate for this time of year. The lawyer asking the melting snowman under the burning sun. For all of you, you should be reviewing your wills, even if you have them. If you don't have wills, I don't want to shame anybody, but you really are going to leave a lot of problems for your family, and if there's no family, your friends or the charities. You really do need to have wills in place. I thought about that a lot over the weekend. Why? Because I was pinned with my girlfriend and others on behind Fissile, between Fissile and Whirlwind, on a 2,300 meter ridge with the hurricane force winds, average speed apparently 100 kilometers an hour, with gusts up to almost 130. And so I thought, I think I've got everything organized, but I did come home and I did update a few things on my letter of wishes, which we'll talk about shortly. So you just never know when that time will come. So there's your simple checklist on preparing your will. Who will be your executor? So yes, ideally the spouse. If you're maybe getting on a bit and elderly, and think maybe your spouse wouldn't quite be up to it, then name a younger generation with the spouse. And then, of course, the beneficiaries. So typically it's the spouse and children. I've had several people contact me recently who don't have immediate family, and so they've created quite a lengthy list of friends and charities who would be the beneficiaries, even favoring them over nieces and nephews and cousins, which was interesting. But it's up to you. You only have an obligation to a spouse, whether married or unmarried, and the children under what's called wills variation provisions. BC, by the way, for those of you from other provinces where perhaps you're familiar with the ability of the courts to change wills to provide just, fair, and equitable distribution for immediate family members, being spouse and children. Well, in other provinces, it's nowhere near as strong as in British Columbia. British Columbia, so long as there's a substantial estate, which is apparently over 1 million, which doesn't seem very much now, but the Court of Appeal decided that a long time ago. The rights of children to receive an appropriate share in the estate is pretty well entrenched, even if they're adults and independent, unless there's a compelling reason for them not to receive. So you definitely want to talk to experienced legal counsel if you're considering a disproportionate allocation of your estate to your spouse or children. And certainly disinheritance should be off the table. I mean, there are different ways around it, and your legal counsel can give you advice. So what proportions? That's always important. There have been lots of great articles recently, which I encourage you to read, that I've noticed as to, you know, if you've got 3 children, one of them has 5 kids, so another one has none, and the other one is let's say, married extraordinarily well and is really in no need. Well, how on earth do you divide up your estate in proportionately? Should it be equally? Well, there are a lot of compelling reasons for it not to be equally, given that fact pattern. And also, of course, there's a consideration of children of, let's say, your new spouse. To what degree should they be receiving commensurate to your own children? For those of you, this is designed for mature action communities, so I'm not sure if too many of you have minor children. I actually do, so it's an important consideration who would be the guardian. And certainly, for most of you, it would be the minor beneficiaries would normally be the grandchildren at your ages. So when should they receive it? This is where important considerations in what's called the Testamentary Trust and how that's set up, when and how and under what circumstances and at what age the grandchildren might receive a share of your estate. And that, of course, leads to one other consideration, without getting too technical, is whether the grandchildren should be receiving at all, or whether everything should go to the children and only to the grandchild of your grandchildren, if your child is predeceased, being the parent of the grandchildren, or whether you should carve out a portion of your estate and give it directly to the grandchildren, typically in trust until they're a certain age, with discretion of the trustee to access some of that at the earlier ages. So big considerations. And then, of course, how much to give to friends, family, charities, quite apart from those minor beneficiaries and other children. Next slide, please. So another part of preparing your will is who will inherit the family business. That's a big consideration for me. And there may be some of you. I'm not going to go on about that too much, because hopefully at our ages, we're either retired or ready to retire. But it's a big consideration. And certainly you can deal with that in the will, although typically it's a good idea to deal with that outside of the will, like so much of what we've already talked about and which we will be talking about. So it's amazing how many times I get contacted for people arguing about, photographs, things of sentimental value. So get your pad of stickies out and write the names, first, second, third choice, and stick it underneath the sculpture and put it on the back of the paintings, and keep a list somewhere about who's going to get these personal effects. And hopefully, going back to the communication issue, have a discussion with them as to who wants what. Now, for the charities, I've already mentioned that already. It's a bigger consideration as a result of likely changes to the capital gains tax I'll talk about at the very end. Do you want your executor to write a big check to the Receiver General, Canada Revenue Agency, or would you prefer that check to be much smaller and a nice big check written to the charities of your choice? There are excellent ones in Whistler that you would know about. Then the Whistler Community Foundation is the umbrella organization if for whatever reason your specified beneficiary isn't actually a registered charity. There is a way around that. If it's a nonprofit society that for whatever reason can't achieve charitable status, you can give it to the community foundation with specific provision to pass it through to that non-charity. Do you want to provide direction as to whether your executor can hire professionals? This is becoming incredibly important because of the sizes of the estates and the complexity associated with them. And there isn't, the law does not presume, and in fact does not allow in many cases, without getting into too much detail, the delegation by the executor of the executor's duties. And so really, you do need a little bit more sophisticated will with that specific instruction. And in fact, it's very helpful if you have some professionals that you trust to not necessarily list them in the will, that's a little bit unusual, but to have a letter of wishes associated with the will and say, you know, if you have tax problems, then please call my tax accountant or my financial planner. And then, of course, we've already mentioned the burial and cremation information. So next slide. So of the incapacity documents, so again, will is only effective upon death. The incapacity documents are during your mental or physical incapacity. The power of attorney, as it states here, allows one or more persons to manage the financial and legal affairs if you're unable to do so on your own, and that, of course, ceases when the person dies. Now, there are a few points from this to glean, and that is that you do need quite a formal document that either should be lawyer or notary prepared, or the government website, the BC government website, if you Google it, does have a fairly good example, though it is pretty simplistic and doesn't allow for more than one person to be appointed. For mental or physical incapacity, to make decisions about your financial and legal affairs is incredibly important. I often get phoned by people who say, well, I have no idea what they actually wanted. I know I've got this authority, but I don't know how to use it. And so it's useful, again, to have a separate letter of wishes setting out some more details, which you can update from time to time without having to go back to the lawyer or notary, as to what your wishes would be if you're at that mental or physical incompetency stage. And again, it ceases when the person dies. Now, I have had several instances recently where someone's been on life support systems, and I've said, please keep them on life support. Please don't disconnect them yet. We've got some considerable financial planning that and you know, using the power of attorney to minimize the taxes that would automatically occur upon the death, being a deemed disposition under the Income Tax Act. So can be very useful then for that power of attorney to be used in the final hours of somebody's life to maybe move property around or to change some of the investments. Lots more to talk about, but limited time. We'll keep going. Next slide, please. So we talked about the power of attorney being for legal and financial decision-making. The representation agreement is a fairly new creature. I guess it's about 6 or 7 years old in British Columbia. I came out of Ontario, which separated the health and personal care decision-making from the power of attorney, which beforehand, I guess almost a decade ago, covered everything. So again, the representation agreement allows you to appoint another person to make decisions regarding health and personal care should you be unable to communicate your health care wishes in the future. And that person appointed must follow your wishes as best possible. And again, this is actually can be a very, very simple document, but that's often not as helpful as it should be, because the person might have no idea, and it might be about what your health and personal care wishes are. And the person, like the healthcare facility relying upon your authorization in that, might be a little bit hesitant about accepting your word as the representative to give them a green light on something if it's not expressly set out in the representation agreement. Again, there is, along with that power of attorney, a sample one to fill out on the government website. But again, pretty simplistic. I do highly recommend you consult with a notary or lawyer. And it's a good idea maybe even to have it notarized in order to for there not to be any question about your mental capacity at the time you're giving it. Next slide. So similar, or really an adjunct to the representation agreement, is the Healthcare Directive or Living Will, which is sort of, I guess, street parlance for an advance directive written statement of your healthcare wishes. Now, this is becoming much more important as a result of new law that occurred overnight, which I've just found out about just before this presentation, which I'll talk about very shortly. And so, again, an ancillary document to the representation agreement, which provides specific direction. And I'll talk more about it when we get to the slide a little bit further on. Next one. So I'm a big believer in these letters of wishes. If we could go back to, I think it's slide 8. So the letter of wishes supplements the will, the power of attorney, the representation agreement. We'll go up to, I think it's the next one. It might be slide 10 now. Yeah, next slide 10. This is what should be updated from time to time. This is what I updated when I came down off the ridge, a bit shaken from being bowled over like a bowling pin by the wind. It's an informal document written that can accompany the will. It can also, as I've mentioned, accompany the power of attorney when it deals with financial and legal decision-making, and it can accompany the representation agreement for health and personal care decision-making. Now, when I say it's not legally binding, it does have very strong persuasiveness these days. The way that the courts are interpreting what are somebody's testamentary intentions has really evolved in the last 2 years, 3 years, and it will continue to evolve, such that the pendulum's really swung from the old law that was in effect up to 6 years ago, that came from 19th century Britain. You only look at the 4 corners of the will. You can't look outside it, except in very exceptional circumstances. And now the pendulum swung right over to the other side, which says that really anything that the person has left in writing typically, but it can also be on the computer, we've just got a new decision on, forms part of the testamentary intentions, those wishes that occur upon death by the will maker or the deceased. And as a consequence, diary entries can all be part of that. So make sure not to contradict what's actually in the will, but you can supplement it with the letter of wishes, which should be updated every year. I update mine as to, for instance, what more specific provisions you instructions you want to give to your trustee for how to dole out the money to the grandchildren as that evolves, as the grandchildren get older, as you see their vulnerabilities, their strengths, whether you want to use it as an incentive to get a college degree, match dollar for dollar from the trust, what they're able to earn. All those sorts of things are not dealt with in the formal legal documents, quite rightly so, because they change from hour to year to decade. But in your own words are extremely useful and very persuasive to the court if they need to look at it, but certainly to the executor or trustee in carrying out your wishes. After all, that's the whole point of this, is to, after your death, is to have the distribution occur in a way that you would want during your lifetime. And the other letters of wishes would, as I mentioned, be relating to the incapacity documents. So you would want the instructions on what happens if you're on life support systems. Most of the representation agreements that I've seen, the ones that I certainly do give pretty clear instructions. But as medical assistance in dying, as I'm going to talk about, as it evolves and as we find out how much easier it is now as a result of the new law, it might well be that you want to create a separate letter. I'm pretty sure the BC government's going to create, and if not the federal government's going to create updated forms that will allow you to add to your wishes, to your will, to your power of attorney, to your advance directive, and then you would have a made declaration. Next slide. So this is maybe a pretty hot topic and of greater interest than some of the generalities that I've spoken about thus far. For those of you from other provinces, you all have probate fees. The only one that doesn't, as far as I know, is Alberta, but they're probably going to have one soon because they have a big hole to fill for their deficit. So probate fees, simplistically, are what you have to pay the BC government, assuming you're applying for the court authorization for you to act as the personal representative or executor of a deceased person, having been named in a will, or if there isn't a will, applying to be the representative or administrator. And so it's based on the value of the assets on death. You can deduct the mortgage on your principal residence, but otherwise, if you've got $1 million net of that mortgage, then there's got to be a check written for $14,000. So we are pretty sure, we senior practitioners have been talking about this a lot. We're pretty sure that the BC government is going to have to put it up. They really are in desperate need of some revenue generation, and it's just a really easy, low-hanging fruit for them. And they can do it overnight. They have that power, and it might well go up to 5%. And there's some speculation it might be as high as 10%. So as a result, you really do want to, and this would be probably with the next budget, although it might be a surprise ahead of time. Which might be so in the next couple of months. So there are certain tax minimization strategies relating to probate fees, which you might wish to speak to your professionals about. Capital gains, that's a much bigger issue, but 1.4% doesn't seem very much. But if, for instance, you've got a life insurance policy at $3 million that you've been carrying, that's a big whack to have to pay if you haven't been careful enough to designate the beneficiaries on that life insurance policy. Capital gains in Canada, I'm sure many of you are more familiar with the capital gains issues, where we had the 75% inclusion rate before the Harper government came in, and then the Conservatives broke it down to 50%. And there is a lot of talk about it going up with the next budget, which will probably be in April, up to the 75% again. So you want to talk to your financial advisors and your tax accountants about doing something now in anticipation of that. Certainly for those lucky ones of you who have secondary residences, of course, they're not protected from the capital gains with the principal residence exemption, you should be very concerned. And there should be some strategies that you should be engaging in consultation with the qualified professionals. The last big tax is the property transfer tax in British Columbia. There are lots of great exemptions now when there's a transfer to the next generation. The exemption does not exist now for transfer sideways to siblings or cousins. And there is some talk, in fact, quite a lot of talk about those exemptions being eliminated or at least restricted. So if you are thinking about transferring properties into family members' names, then you might want to do that sooner rather than later. So next slide. Oh, so this is the one that's hot off the press. It's not shown here because I didn't do the slide this morning, is that the Senate did quickly pass or approve the bill that the Liberals had presented for amendment of the criminal code. And so for medical assistance in dying, these, what I mentioned here is imminent changes. Well, those changes came overnight and it was passed into law. Very quickly. It will permit MAID even if the natural death is not reasonably foreseeable, which was the test for the last 5 years since the Supreme Court of Canada ruled the portion of the criminal code restricting or prohibiting medical assistance in dying as being unconstitutional. So as a consequence, this will allow greater freedom of choice, and there's still a lot of safeguards in place. I'm just reading the Global Mail. And the Globe and Mail article talks about people suffering solely from mental illnesses as having to wait 2 years to gain the same right as those intolerably suffering, quote unquote, Canadians who aren't near death, nevertheless gaining the immediate right to seek medical assistance in dying. So a very hot topic, a big issue. Please do educate yourselves. And as I'd mentioned, I expect that there will be the updates to the current forms that the BC government has pretty shortly in order to have people fill them out ahead of time. Next slide. Oh, good. I've got my favorite cartoon, estate sale, all the stuff my kids said they didn't want to inherit. And isn't that the case? So final musing. So I'm just circling around again to the importance of being prepared and communicating clearly with family and friends. Family more so, of course, than friends. If you don't really have family, or you don't want to talk about it with family for whatever reason, which is unfortunately often the case, then seek out your trusted friends and get their input. It's just as a side note, it's really useful if you can talk to somebody who's gone through the process of being executor or personal representative for somebody who's incapable. That personal experience is really, really valuable, and you can get a lot of insight from that. Or you can talk to me about it, but of course I'm not free. Vital to get professional advice, both legal and tax. I hope that I've impressed upon you the fact that estate planning is a rapidly changing and evolving field. It's complex. I've just hit on a few main points. Each of the points I made could be a full day's discussion seminar. And get your referrals word of mouth within the community. We're fortunate in Whistler and in the Sea to Sky to have some really good lawyers and really good tax accountants who are experienced and knowledgeable, helpful, and reasonably priced, in my view, anyway. Keep abreast of current topics. I already mentioned that. Attend webinars like this, and I hope Mac can put on some more. As I said, Diana Sillery, I'm sure, is standing by ready to talk about the usefulness of life insurance and financial planning in general. Just circling back to the very beginning, and I don't see enough of this. I'm really surprised that during your lifetime, so long as you're capable of doing it, and it's not going to considered to be a mistake in hindsight, really think carefully about gifting or loaning at a low interest rate to family members and those in need. Probably should have that in writing. Probably even better would be to have a lawyer look at it as well, just to make sure it's legally binding and the circumstances are right. The benefit, of course, of loaning is that you can ask for it back if you really need it for your own medical care or long-term care facility costs. Or if, for instance, as is unfortunately often the case, there's a matrimonial breakdown, you're giving the money to your son, it's used for family purposes. If it's a gift, it's pretty hard to characterize that as being a repayable loan. So you want to document it properly. And if it's a lot of money, I would seriously consider, let's say over 25 or 50,000, seriously consider actually registering as a mortgage against the property and getting some collateral for it, whether it be a vehicle, just to ensure that it could be repaid. It can be repaid if you do demand it back. So finally, stay healthy, enjoy these golden years. We're very fortunate to live in an age of abundance in the most beautiful spot of the world. Stay healthy is all I can say. It's great that we've got governments that look out for us. We've got an incredible healthcare system. A big shout out to our healthcare professionals. We've got amazing people at our own Worcester Healthcare Centre, as well as Pemberton and Squamish. And so we are truly blessed. Just make sure that you're organized for the inevitable incapacity and then the even more inevitable death. Thank you.
Thank you so much, Peter. That was I know I learned a lot in the last 40 minutes. You know what particularly resonated with me, and I'm in my 30s, but the discussing proportions of your will. My family, we actually just had that conversation, and it was so interesting. You know, for example, one of my brothers is extremely sentimental about our family home. and we had no idea. And he doesn't want my parents to sell it. He wants it to stay in the family. So if we hadn't had that conversation, we would have never known that he wanted to live in that house basically. And we also had to consider, none of us have children yet, but I'm a government employee with a stable a good pension plan, and my spouse is also in a good position, whereas one of my brothers is a farmer and the other is a musician. So we talked about who might need more down the road. Hard conversation to have, but really, really useful. So I'm with you. I'm with you on that. Folks, we have plenty of time for questions. We have 20 minutes remaining until 1 o'clock, and I'll repeat that you can either ask us questions using the Q&A function, or you can ask us questions using the chat. And if you send the questions to the chat, they will remain anonymous. And if you use the Q&A, your name will be associated with your question. So just keep that in mind. I know that we also have Diana as an attendee. I can switch Diana over to a panelist if we want to hear from her. Oh, I think we have a chat question. Oh, we do have a question. Yes. Can power of attorney override executor?
That's a great first question. Thank you very much. So again, the power of attorney only valid until death, and then at death, it's the will then kicks in, and it's in the will the executor is appointed. So there is no overlap. But just as an ancillary to that, that's maybe a simplistic answer, because there's this real developing area of law and interplay between how much the power of attorney, the person appointed under the power of attorney, called the attorney, just not to confuse it with lawyer, how much the attorney does and what they do impacts the estate. So it's a real problem, just practically speaking, if there's a different person named as the power of attorney and a different person from the person named as an executor in the will. Ideally, it's the same person who can then continue that pretty onerous job through the death phase and then on to the post-mortem planning phase, because I have seen several instances where the executor has not known, has been confused or has been concerned about what had occurred prior to the death under the auspices of the power of attorney holder. So huge area of law, developing area of law. It's the practical point arising from this that I want to make is that perhaps seriously consider having the person in charge of your legal and financial decision-making during your incapacity also be the executor of your will. Typically it is that, but I think there are compelling reasons for that to be almost a necessity due to the changes of the way that law is being interpreted about what happens during incapacity and what happens after death. Thanks.
I think we have I guess this is a comment from Kathy White, saying that often the power of attorney / representation agreement person also has time to control the sale of real estate. What happens if the other family members don't agree about selling the property?
Wow, great question, Kathy. That's true that it doesn't really matter. I mean, the power of attorney is acting in the best interests of the person who's given him or her that power. And so the simple answer, again, is, you do what's in the best interest of the incapacitated person. It's just that the way the question is asked is very good, because if, for instance, that's at the very end of life where the power of attorney is just about to expire and then transitions over to, the will, where the courts have increasingly looked at that and said, the power of attorney really should be looking at being responsible for the estate after death. And so senior practitioners are now counseling their clients that they've really got to be looking in the rearview mirror over their shoulder as well at the beneficiaries under the will, those who are going to receive under the will, and make sure that whatever decisions they make during, before death, isn't going to be something that's going to have them all lawyer up, saying, well, you didn't do the right thing in minimizing taxes, or you favored somebody over somebody else as a result of that asset transfer. I could go on a long time on that question, but thanks, Kathy.
Oh, Kathy, anything to add? Nope. Okay.
Nope.
Another question from our audience. How is a representation agreement different from a healthcare directive?
Right. So healthcare directive is usually pretty specific. It just deals, and they've been around for a very long time. They deal with the end of life rather than, mostly with the end of life, rather than with that possibly lengthy period of time from partial incapacity, mental or physical, right through until death. So the representation, I've seen lots of one-page advanced directives or healthcare authorizations. The problem with those is that, for instance, there was a very well-known case that a friend of mine argued in the Court of Appeal and was amazed that the healthcare authority won it, where somebody had said that, and she was a registered nurse, she had made it very clear that she didn't want to be kept alive. And yet the Court of Appeal in British Columbia decided that because she opened her mouth slightly as the spoon came near her face, that indicated a willingness to live, and that overrode the rather vague provisions of the healthcare authorization. I know it's a tragic case, terrible, terrible. And but it did provide a terrific impetus to quickly pass the new law, the new representation agreement, which allowed for these very detailed agreements and set as a template an example of the sort of detail that needs to go into them to clarify those sorts of horrendous decisions that needed to be made upon whether or not to continue to provide for life-sustaining, life-saving measures, heroic measures. Yeah.
Thank you, Peter. We've got a bunch of questions rolling in. This is great.
Of course.
The next question is, can you repeat or clarify what is the gross amount on which the government is going to charge the probate fee? And then they say further, so is it probate fee or rate will be based on the entire appraised or assessed real estate value, or will it be charged on the resulting equity after the mortgage has been deducted?
Right. Perfect. Very, very good question. Thank you. So there's no probate fee for the value of the estate up to $25,000, and then it's a smaller percentage, 0.6%, from 25 to 50,000 of the value, and then the amount over 50,000 attracts the 1.4%. There's a lot of discussion that I mentioned, which I said is the maximum. There's a lot of discussion about there being a continued graduated increase. For instance, that the 1.4% would stay up to the first 500,000, and then it would go up for 3%, a bit like the property transfer tax that those of you who have valuable properties may have had to pay. And so you only it is based on the gross value of the estate. The only thing you take off is the mortgage value on your principal residence. And typically we're allowed to use the assessed value. So, for us, if somebody died, it would be the July 1st, 2020 assessment, which is shown in the 2021 assessment. And that's usually fine, acceptable. And usually is not questioned. The only time it might be questioned is when you then sell the property and it sells, which might well be the case these days, at 50% or even double of what the last year's assessment was. And then the government does have an opportunity, and there's discussion about them perhaps auditing more of these in order to capture the higher amount of the probate fees resulting from that revised valuation.
Next up, Does the letter of wishes refer to the will and vice versa? Or should the letter of wishes refer to the will and vice versa? And what arrangements are necessary to ensure that it is known the letter exists?
Okay, people, you're hitting it out of the park. This is just great. These are all excellent
Sent
questions.
these questions, Peter.
So again, this is sort of an evolving area of law. As I'd mentioned, the courts actually want people to go and look for any testamentary intentions. That is, intentions that someone who's deceased, they wanted their wishes to be fulfilled upon their death. Typically, of course, historically, it's always only been the will, as I'm just mentioning one more time. But now, supplementary information can be, and in fact must be, introduced to the court if you find it, like a letter of wishes, like less important diary entries or musings on the computer if they're downloadable. And so the answer to the question is, it depends. That's often an answer to a lot of these questions. So ideally, your letter of wishes references the will and says, with reference to paragraph 3A, where it says that the trust is for the necessities of life for my grandchildren, this is what I consider the necessities of life. And by the way, in extraordinary circumstances, I don't mind if, a sum of up to $5,000 is used to transport that child to the university of their choice. So you can, hopefully reference the will. And for instance, if there's a guardian and you say to the guardian, I'd like you to resign as guardian if you're not prepared to move to Whistler and live in our home and take care of our children, as an example. Sorry, what was the second part of the question? I didn't write it down.
Just what arrangements are necessary to
Oh, yeah.
ensure that people know the
Yeah.
letter?
And so ideally, these letters of wishes are with the will. Please make it easy for the executor to find them. Or you can give copies to the executor. Just make sure to date them, preferably witness them. It just increases what's called the probative value. The evidentiary burden is then is greater if you can show that, for instance, it's in your own handwriting and that you were mentally competent when you signed it. So ideally, you do make sure that your designated person who's in charge of these things knows where the originals of all these documents are. Fortunately, just one more side note is, fortunately, our practice is to scan the originals, which then leave our office with the clients, and then send it electronically. And so if for whatever reason, for instance, the fire that burns down the house, that kills the person and destroys their paperwork, and I've got proof that there's those are the originals, and so my printout of the electronic copy should satisfy the court.
Mm. We have a comment here from Diana that I'll just read out. She sent it to all attendees, but I'll read it out here as well. So Diana says, regarding beneficiaries on any investment accounts or insurance, if you have anything from or still in other provinces, make sure you have someone review. And then she adds, Quebec is another province that doesn't have probate either.
Absolutely, and that's precisely why you want to speak to a qualified person in that area, and why I always say, I'm giving legal advice. Go get your own tax advice. Go get your financial planning advice, please. These are all professionals who are acting in your best interest. There's, you're just, if you haven't got your team who should be talking to each other as well, as I do often with Diana, if you haven't got your team, then you're not moving on in a prepared way. And just circling back, communication with family members, communication with professionals is key in all of this.
Our next question is from an audience member who has said that they do not want to be resuscitated in that situation, but they've asked, how can I be put on a ventilator or intubated or what have you long enough for my children to move assets around?
Yeah, that's a great question. And it does build on what I'd mentioned in that we professionals can save an estate an enormous amount of money, or regulate things, or finalize things that perhaps were only talked about. And I'm sure Diana has the same sort of stories as I do with these last minute things. And yes, I've actually written into our standard wording additional language saying, for instance, once the decision is made, I want my relatives to be told, and I want them to have an opportunity to come and visit me. And I'm not sure how that jibes with the medical health care system, but keep me alive for the, up to 2 weeks, that period of time, for people to come and see me while I'm still alive. And then they can stay for the celebration of life, is an example of delaying that a little bit. Again, there might be problems with, occupying a critical care bed or intensive care bed in a time of COVID or other health emergency, but certainly not just for relatives to visit from afar, but also for some tax and estate asset changes to be made prior to death is certainly salutary. Yeah.
Another question here. When a person passes away and has no children, no signed will, and let's say, for example, that person owned a house, does the BC government guardianship take over the right to sell the property?
Right. So there are two things I can talk about there. One is there's mention, it's actually called the Public Guardian and Trustee of British Columbia, which protects and the rights of elderly, infirm, and the youth, the under 19. And they perform a very valuable function. I highly recommend that you read their background on their website, because you may be relying upon them if you don't have immediate family members. And if you think that there's any sort of mental or physical abuse of elders, or if someone is spending the money of a teenager, as a trustee, you can whistleblow, and they will investigate, and aggressively and very professionally. And then the other part of the question was, what happens if you die without a will? Wow, that's great, because I actually skipped over that. Incredibly important. In British Columbia, the law changed about 6 years ago. And if I can just take 2 minutes on this, if you die without a will and you don't own your property with your spouse, then your spouse doesn't automatically get the property. There's what's called a preferential share of 300,000 that is allocated to the spouse, and then anything above that is shared equally between the spouse and the children. Except if the children are of a different marriage, but still your children, then that preferential share is only 150,000, and then the rest is shared equally between the spouse and the children. The problem with what I just identified is that you may expect your spouse to get everything, but in fact, they're only going to get a limited amount, with a lot going to children, and the spouse might have to use up that amount to buy out your property. Again, it's a bit of a complex topic, but it should be strong encouragement for people to actually get a will together and make quite clear their distribution wishes.
Mm-hmm. Yeah, wow. That's great motivation, I'd say. We have one more question, and maybe we'll say that this is our last of the day, and it's actually a follow-up from our friend who asked about probate a little bit earlier. They are asking, to be clear, do I understand correctly, on secondary real estate, the government charges on the value, including the mortgage, even though the assets have an equity that could be much less?
Yes.
Easy answer.
Yep.
Okay, the answer is yes, my friend.
There's one more question about TFSAs.
Oh yes, that just came in. Does that mean I should close my TFSA?
Well, that's a bit difficult to answer, because it could be under whatever circumstances. But TFSAs are very useful. Again, they can be withdrawn tax-free, unlike your other registered investments. So I would say that if you need the money, of course, you should consider that. But indeed, it's very useful that it forms part of your legacy if you name the beneficiaries correctly on them, because they would receive those tax-free.
Mm. And Diana pointed out that they can also have beneficiary designations.
Oh, yeah. Yeah.
Yeah. Okay, wonderful. Diana, if you don't mind, because somebody asked if I could share your contact as well. We have Peter's contact here on the screen. Um, Diana, do you mind putting your email address in the chat if you're comfortable doing so? I can also send it out because I'm going to send out the recording of this session to everybody.
And while she's doing that, just one final question I saw, which is important, and that is that if you don't have a will and you don't have immediate family members, no, the government does not get it does not escheat to the government. It goes up first to your parents, if there are any surviving. If you don't have parents surviving, it goes to siblings. And if you don't have any siblings surviving, it goes to nieces and nephews. But it goes no further than that. So it does not go to cousins, for instance. And it doesn't go down to like grand nephews and grand nieces.
Interesting. So they'll try. They'll try to find an immediate family member. Well, thank you so much, Peter. Thank you, Diana. Diana just popped her details in the chat, and I will also include those in my follow-up email. So don't worry if you don't get those down. Peter's details are here, and I think he is more than happy to hear from those of you who are local. If you're looking for further advice, or like he said, if you have specific questions. You're going to need to get specific advice. Uh, and Peter, any final thoughts, final words before we clue up for the day?
No, it's just a real privilege to be able to share some of this useful information, and please spread the word. Get yourselves organized, even if you're healthy. If you're on top of a ridge at 2,300 meters with 130-kilometer winds at you, you just never know when things are going to happen that you don't expect.
Amen to that. Kathy or Sherilyn, anything you want to add on your end? I mentioned at the beginning, our next session is April 15th at noon. You can email me to register, and it'll be arts and culture themed.
Yes, that's right. Thank you so much, Jeanette, again, for facilitating the meeting today. And Peter, as always, awesome. Thank you. Excellent advice. And Diana. Diana Sillery is also super. So thank you so much on behalf of Sherilyn and myself, and the Whistler Mature Action Community Group is here as a resource as well for people that are 55. You can join our membership for free. We provide advocacy, fun, engaging events, and we just want to keep you informed with what's happening here in Whistler. We are working with the resort municipality as well right now to create an age-friendly plan for Whistler in 2021. They've just hired, you are all the first to know, they've just hired a consultant to help in that process to align with the World Health Organization age-friendly planning. So the community will be engaged in that, as well as the Whistler MAC group. Join our Facebook page. We also have a WhatsApp. Hello, we are with it. And we also on our Facebook page and on our website. And as a member, you don't have to join Facebook. You can just join our website and we'll email you updates similar to what we're talking about today, our sessions of discussion and engagement. We are also working with the Whistler Community Services Society, Social Services, about doing an event with them called Activate and Connect, which will have other topics that we'll be bringing up in the future. So keep informed, keep engaged. We're here to help. Thank you, Jeanette. Thank you. And I'll go be available for any questions afterwards as well. Sorry.
That's okay. I'm just going to mention one other library program that may be of interest to you. We have a Money Matters Finance series, and the third session is coming up on April 7th at 7 p.m. And the topic for this session is, well, keeping your money, which is investing. So we're going to be talking about stocks and bonds, mutual funds, exchange traded funds, levered investments, real estate, and a few other bits and pieces. So I'm sure there's some overlap in the audience for those of the folks who are here today. So if you're interested in signing up for that Money Matters series on April 7th, you can email me and I will sign you up for that. It's a great series. I've learned a lot about it, or a lot from it. And yeah, I highly recommend joining us for that as well. All right, my friends, I think it's time to say goodbye for the day. Thank you so much for being here. Thank you, Peter. Thank you, Kathy and Sherilyn. And we will see everybody in April. Bye.
Bye.